So hello everyone, and I also want to join and congratulate for this very happy occasion and event. And first and foremost, thank you, David. You made a long trip, long journey to join us, and we are very happy to have you here. And I would like to share with you some words about our center, first of its kind, a Non-Adversarial and Therapeutic Justice Center. So I can proudly say that since it was founded in 2015 by Dr. Perlman, we, as I said before, we turned some of the vision into reality. And I will forget few of the events that we already took, maybe because I cannot describe all of them, or that I need to briefly give you some words about the center. But the center's mission is to lead the development of theoretical research in the area of collaborative and TJ, to promote public and professional discourse in Israel on the issues involved in non-adversarial and TJ, and to contribute to the shaping of professional practice for those actually involved in handling collaborative proceedings. The center aims to serve the academic and professional communities, such as judges, lawyers, mediators, social workers, psychologists, and other professionals that are involved in the management of therapeutic and collaborative proceedings. So I would like to share some of our actual events that we took and activity. So among them, hosting seminars and conferences, dealing with non-adversarial and therapeutic justice. In that matter, I will give like a short example. We started 2018 with a very important and very unique topic. A conference was dedicated to mediation, therapeutic law, and military service. And we touched that issue in other aspect, which is, of course, a very interesting and important topic. We are providing advanced courses and training workshops for professionals involved in collaborative and therapeutic procedures. For example, the center, together with the Israeli Psychologist Association, organized a workshop on family disputes between mediation, treatment, and intervention in family disputes by mediation and mediation techniques. Mediators, lawyers, and psychologists participated in the workshop, including lectures and practical aspects. We are also dealing with shaping TJ within among lawyers, and we emphasize the need to change the legal education and training of lawyers in a manner that will increase the efficiency and quality of mediation procedures in general, and will reduce the opposition to their inclusion in family meetings and individual disputes. We are promoting academic researches and, for example, position papers that we heard about it earlier today on ways to manage claims on IDF disabled veterans, and developing teaching materials. We are very proud that a group of students coached by Dr. Perlman participated, for example, in an international competition in the International Chamber of Commerce, and even won the first place in the category Best Creative Solution Generation, and receive a certificate of excellence for their great achievements. Formulating positions papers and promoting legislation. For example, we submitted behalf on the center a legal opinion to a parliament member concerning a mediation bill. There is a big discussion in Israel concerning the regulation of mediation and TJ, and we are trying to be also very active in that aspect. And we are always seeking to collaborating with ventures and organizations in Israel and the world. And of course, this event is one of the most important. So thank you very much, everyone, for joining us, and congratulations.
Okay, well, I'm very pleased to be here. And this long title is Facilitating the Therapeutic Application of the Law, which is abbreviated as TAL, through the Amicus Justitia brief. These are a couple words I used earlier today, but really it's a different type of legal writing that I think might be important in TJ, and might be of interest to courses and to students and projects for students as well. So what it does I'll back up even before I do my slide 2. We know of therapeutic jurisprudence as having a kind of conceptual framework of looking at the law as a potential therapeutic agent. And when we talk about the law, we're talking about rules and procedures, what we really think of as the law. And we're also talking about the roles of legal actors, lawyering, judging, and others like therapists who are working within the legal ambit, how their work fits in with the legal system. So the rules and the procedures, we talked earlier today about terminology and development and discourse and how it's changing and developing. Used to talk about rules, procedures, and roles and procedures not thought of that much together. Now we're thinking them often as together, being the legal landscape or the legal structure, or we can think of them as bottles to have a structure. And these are really what we do when we're doing the therapeutic design of the law. So there's a relationship between that and the application of the law, but the design of the law are really, the statutes that we're going to pass, the regulations that we're going to pass, and those are the structure or the bottles. Then we have the roles of legal actors. These are the practices and techniques used by lawyers, judges, therapists, criminologists, and others. And we think of them as a kind of liquid or wine to be poured into the existing bottles. And if it fits, great. If it doesn't, then it gives us some thought, some thinking. It launches some thinking about whether we might be able to change the law to make it more TJ friendly, for example. So here there's this important relationship between the design of the law, TDL, and the application, TAL. In original TJ work, there was very little of that. Someone would find a rule and write about how therapeutic or anti-therapeutic it was, or a procedure. Adversary adjudication of child custody cases, very anti-therapeutic because it gets the parties to go after one another and to think of the worst about the other, and it adds to the trauma and of the legal procedure. And so there are alternatives like mediation, collaborative divorce, and so on. But we used to look at them very much alone, the rule, a procedure, or the role of a legal actor, how a judge conducted a certain hearing might lead to greater compliance by an offender. But there came a time where the relationship became quite evident there. And I don't know if in this presentation, whether I talk about that or not. It's interesting, but it may not be crucial to what we're doing today. So the goal now of TJ is to pour good TJ practices or wine into the relevant bottles. And so you can have some examples. I have some from the US. A federal diversion law is a really terrible bottle, because a prosecutor who wants to offer diversion to someone, who has the right to do so, and who actually decides to do so, presumably does so with the notion that this will be accepted and hopefully will succeed. And yet, the federal diversion system is a really bad bottle in the sense that we know the kind of practices and actions and words that a prosecutor should use, either orally or in writing, when offering diversion. Excuse me. This is your first offense. You've had a pretty good trajectory up until now. We think you got a bit off track. We do have a diversion project here, and you seem to be a good candidate for it. This is what it entails. It seems to me you could be very successful at it. If you were, we would drop all the charges. You'd go back, and you'd have a good, productive life. None of that can be said in the U.S. Diversion. It's not really a statute, it's actually a manual drafted in D.C., but it's filled with legalisms and incomprehensible language and what you're waiving, and here and before and where and after, and all of those kinds of things. And it doesn't apparently, I mean, I actually looked into this and asked U.S. Attorney's Office, can you send a cover letter that explains this a little bit differently? And they said, no, it's the form. We just follow this form, or we don't do anything. In fact, in Puerto Rico, where the population is basically Spanish-speaking, but the federal courts, unlike the state courts, are in English. I asked if they have a Spanish version of it. No, it can't be translated. So they get something that's so foreign and incomprehensible, and they have to sort of wade through it. It's not long, but it's a lot of wading nonetheless, and then decide if they want to opt for this program. If they do get through it and opt for it, even though it has all of this discouraging technical language, and they do well in the program, the prosecutor simply has another form that says whereupon, hereupon, blah, 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 everything's dismissed. No opportunity to say congratulations, we're glad we offered this to you. Those things I'm talking about are the kind of wine you would want to be able to use in these bottles, and very consistent from what we know from psychology and criminology and social work about motivation and congratulations of someone, but you can't do it. So it's just a bad bottle. Okay, now it doesn't have to be that way, and some jurisdictions have very little that they say about this, which is better than saying what the feds say, which makes it hard. So it's really an example of a bad bottle. If you had a good bottle, one that allowed this kind of conversational, that's what you would have. You would have letters saying, we're pleased to offer you this, we think you could do well, here's what it entails, and so on. Criminal settlement conferences. Again, the federal bottle is terrible. Why? Because you can't have a criminal settlement conference that involves a judge at all. The federal law says judges can't be involved in plea negotiations of any sort. No judicial mediation, but the state of Arizona and a number of states have a pretty good bottle. When we say a good bottle, we mean good in terms of potential. Okay, it could be used in a good way. It isn't necessarily being used that way. And in many jurisdictions, you have good bottles that are just not being used in a good way because no one's ever really thought of it. And that's another important thing that chapters and schools and all could do. So Arizona has a good bottle in terms of its potential application. The idea is if you have a good bottle, one that allows for this kind of liquid, that you pour some good liquid into this existing bottle. That is the therapeutic application of the law. An example of Arizona criminal settlement conferences, sometimes it's not used in a very productive way at all. There are some conferences that are very, very skimpy. Trial judge says, you're making any progress in settling the case? And the lawyers say, well, a little bit. They say, would you like to be referred to another judge for a settlement conference? Okay, we'd like to. And sometimes that other judge merely says, how are you doing on this? You want to think about it a little longer? Why don't you come back in a week or so and tell me where you are? And that's all. So that's skimpy. And it's a good bottle, but it's not being used in a good way. The robust TAL, which is done by a number of judges, one, the late judge, Mike Jones, who some of you may know, a wonderful judge from Arizona who passed away a year or two ago, was a real TJ judge. He had been a mental health court judge or a drug court judge, and I talked earlier today about how you sort of move around, and when he left that and went back to the regular calendar, he brought his TJ skills and interest with him, and he was really known as an excellent TJ type judge. So when a trial judge had some people who hadn't yet settled their case or decided on settling, and he asked them if they wanted a settlement conference, and they said yes, he would try and have them go to Mike Jones. Now, Mike Jones ran something with very inclusive participation. He not only had the counsel there, the two counsel, the counsel and the prosecutor, but had the defendant and the victim and respective family members, and it was very respectful, empathetic. there is also a clause in there saying if things break down and it goes to trial, nothing said here in the meeting can be used later on. And so it became evident that an apology could be attempted there or made there, and he was very much involved in all of that. Really had kind of RJ components, restorative components within this type of legal environment. So that's a good example of how you can have a robust TAL with a good law. Another good law in most jurisdictions is probation and its conditions. Usually there's a lot of leeway for a judge to impose probation, and to set the various conditions. Often it's just set in a standard perfunctory way with no real thought. Or if there have been some suggestions for probation or whatever, they may just be incorporated and the judge says, okay, these are I'm going to put you on probation, here are the conditions, and that's about it. But there are some judges more attuned to TJ who say, you know, this imposition of sentence is really important. And the manner of imposition of sentence is sometimes as important as the sentence itself. And so the judge can actively solicit the input of the defendant. Okay, well, you know, what's your plan? Have you and your counsel talked about this? What would you propose? If I want to consider you for probation, how am I going to be able to sleep pretty well at night? What do you propose to do? What do you propose to not do? And so that is used in a very effective way. Sometimes when you're looking to see if a bottle is potentially TJ friendly or ready or not, you have to look pretty carefully and creatively, because sometimes a law that looks like it's not that TJ friendly can actually have room for TJ application. And a really a good example of this, it was done by, some of you may know Lorena Bartels from Canberra, Australia. She went to work, she went on a study leave or something to Hawaii, and she visited the Hope Project. The Hope Project was started by Judge Alm, Stephen Alm, in Hawaii, and actually by its letter, it looks like it has been, commentators have said, it looks like it's had all the rehabilitation and everything ripped right out of it. It looks like a purely deterrence kind of rule. It basically says if someone is arrested and has some drug involvement, they can be offered or placed on this probation program. And what happens here is they are giving an initial hearing, a warning hearing, where the judge is supposed to say, okay, this is it, this is what probation is like in our jurisdiction, and you call in every morning by 6 a.m. and you're going to find out if your color comes up, red, green, blue, and if it doesn't come up, you go about your day. And presumably you refrain from using drugs and you do whatever. If your color comes up, you've got to report by such and such a time for a urine analysis. If you don't, you're going to have some penalties. You're going to maybe be apprehended, spend a day in jail, whatever it may be. And once that is said, the person goes on his or her way. And there are only follow-up appearances really if there's non-compliance and the judge goes through all of that. Well, this looks like, you know, a really just kind of harsh, deterrent-only kind of rule. And some jurisdiction, and some people liked it for that reason, actually. A lot of commentators didn't, but some did. And it became popular, especially when the results came out and showed that probationers in Hawaii were doing pretty damn well. And so some states said, wow, boy, this is cheap. It's cheaper than a drug court. It's kind of drug court on the fly without doing much, and it doesn't involve much. Let's just adopt this. And a number of states did. And when they did studies, they said, that HOPE thing stinks. It's not doing anything at all. But what Lorena found is that the success in Hawaii was probably due to the fact that there really was some space if you look for it. But if you're a good judge looking for this space within the law that's designed that way, you can find places for it. So she showed how the judge infused the process with robust TJ and procedural justice considerations. And this may explain, probably does explain, its success in Hawaii. To give two examples, this judge held group initial warning sessions. Now, the statute just said you have to have a warning session. It didn't say how you had to do it. He could have had every person come in quickly and just say, okay, here's the deal. You have to call in and this and goodbye. He gave a group session for a couple reasons. Well, one, it does save time to get them all together, but they all saw we're in the same boat as some other people here, right? And we're being treated the same. The fact that the color of my skin is different from that person or whatever, or that I'm transgender and that person isn't, is not leading to me being treated differently by this judge. He's treating all of us the same in this group hearing, and he says to all of them, look, this is a tough program, but you can make it. People have made it before. We have a really good success rate here, and I hope that you'll all be part of it. That kind of statement. There's some videos on this, by the way, of what he does. And it's not that much, but he does it in a really, really nice way. He also took advantage, I said earlier, there sometimes you have sort of friendly design provisions that aren't often used. Hawaii and a number of jurisdictions say that you can have early termination of probation if you're quite successful. And he decided along the way, not at the very beginning, to use it. So sometimes he would have someone come in and say, you know, you've been doing really well. You've been on probation for a year and a half. You've been compliant with everything. You look great. You have your kids back. You have a job, whatever. And come in next week with your family or whoever you want to bring. I'm going to, release you from probation for that time on. So we kind of combine this with like a type of mini drug court graduation ceremony. Anyway, let me go back to that. So it seems to me this is a perfect place to try and capture the importance of how TJ application can do something where if you just read the black letter law, it's not going to look like it has that at all, and is not going to lead most judges, even decent judges, to really think of doing it in those ways unless they're prompted a little bit. Some laws, so that was one that doesn't even look TJ friendly, but it can be if it's creatively administered. Some laws seem TJ friendly, but they have provisions that, if they're interpreted kind of in a quick, knee-jerk way, they could frustrate important therapeutic features. So Puerto Rico recently passed something called therapeutic diversion. And it basically says, our drug courts are absolutely full. And what we want to do is offer diversion to a lot of other people who aren't going to be in an area where there's a drug court and all that. We're going to say, if you're charged with crimes A, B, C, D, E, F, whatever, and there seems to be drugs in your life that's involved in this, we're going to have an interdisciplinary team we can send you to, if you agree, which will prepare and submit to the court an individualized treatment plan and recuperation and rehabilitation. When that plan is prepared by this interdisciplinary team and sent to the court, it says it holds a hearing, and the diversionary treatment will begin, quote, if the defendant accepts the plan's terms and conditions. Now you can take a day-to-day judge who's well-meaning and all that, and give the judge this law, and the judge may see someone and say, okay, you interested in this? Okay, I'm going to send this to the interdisciplinary team that'll evaluate you and come up with a plan. Then when the plan's submitted here, you'll come back and tell us if you accept it or not. If you do, you'll be on diversion. Okay? But what it looks like is that the language may suggest that the team just prepares the report on its own. Here we have this guy, he's addicted, he's this age, whatever, and we're going to, why don't we say this is the plan, that he has to have drug tests this often or whatever, and does this, does that. And then we come up with a plan, and we send it to the court, and he agrees or disagrees. My fear is that that's what's going to happen. It's a new law, and it hasn't really been no one's been prodding the judges about this. But I say such an interpretation, it's literal, it's certainly proper under the law to do it that way, but it would fly in the face of TJ concepts of voice, of hope for behavioral contracting, where it's like a two-way street. And, but no, nothing in the statute says that it must be prepared by the treatment team without the active participation of the defendant or the patient. So of course, it could be, but it has to be the team that says, well, let's really involve this patient actively and say, is this okay with you? And what about this? And this day of the week, would that be a good one to go to this clinic, whatever it might be? So easy to involve the defendant, have the defendant feel that he or she has been given voice, that not just an object of all of this, and presumably should really breathe life into it and help the compliance with it. I remember similar language talking to, in Puerto Rico, to a group from the Dominican Republic of lawyers there. And I said, well, the judge, before imposing probation, could ask the defendant to suggest certain conditions or whatever. And these people said, wait, the law says the judge shall impose. And I said, yeah, it does, but it doesn't say the judge shall not talk to anyone before imposing. And yet they were coming from and very often the more civil law tradition is a little bit more literal, it seems, than the common law tradition has been on that. And it's just a bit of a hurdle. We call those sort of cloudy bottles, because those are bottles that can be good, but it takes some real interpretive effort to have them work in the right way, in what we would consider the right way. So my proposal here, and I've thought this for a while, we need a different kind of legal writing, not to replace everything else, although to replace some of the stuff that we write, but a different kind of writing that's kind of short and to the point and can be practical and read by different members of the community. And especially when we're talking about TAL, because as I mentioned earlier, TDL, the law itself, it's official, it's written, it means that it's sustainable by and large. No one's going to forget that law is on the books. And unless it's repealed or declared unconstitutional, that law is kind of sustainable. But that creative interpretation of the law is in no sense sustainable. But it could be easily made so by having a short little written document that goes not to the highest court of a state or a jurisdiction like an amicus curiae brief, but rather to treatment teams and to trial judges and to defense lawyers and prosecutors. And it says, we have this diversion statute, and the literature really strongly suggests that if we implement it in a kind of robust way with the defendant's participation in the formulation of the plan, it's much more likely to work and to be felt and to be regarded as fair. And so here it is. And then we hope that this little thing might be cited in statute books where they cite some cases that interpret it, sometimes law review articles. They could cite this little blog or whatever that talks about an amicus curiae, an amicus justitia brief on the therapeutic diversion law, or an amicus justitia brief on the HOPE law from Hawaii, so that people who are going to adopt it will get some feedback hey, if you adopt it, don't just adopt it because it seems easy. You just have a hearing and then you leave the person alone. You have to have a judge here who's going to really be promoting this kind of project. And that's really it. These briefs, I think, could be good assignments for students, and could be a few page blog. The other thing is, I think once a student does this a couple times, they now are set in terms of TJ methodology in their thinking and in their practice. They're very likely to think about laws and their application and how that application can be made good. I had some example here of an expungement hearing that came to my attention, and it's a clearly TJ-friendly law. It allows someone to petition after X number of years to get rid of their record, and but it's interpreted in practice in the most perfunctory way. Now, generally, petitioners are not complaining about this because it's usually granted. They go in, they petition for this, and it comes to court, and the judge and the prosecutor, they're told to bring 3 witnesses. The witnesses show up. The prosecutor doesn't talk to them till that moment, says, how long do you know this person? What's his reputation in the community? Says, okay, you guys wait here. Then the judge comes in, the defense lawyer introduces himself and says, we have the petitioner here who's seeking to expunge this conviction, and he's been, record-free or whatever, crime-free for X number of years. We have affidavits from the witnesses that he's got good character, and the judge says, okay, how are you doing? Okay, granted. And so everyone leaves happy, but it could have been, it seems to me, a much more animating experience. Even the defense, the prosecutor could have said, hey, this person's doing really well. I'm pleased to join in this application to expunge. And the judge could say, yes, you've done really well. We're really pleased. Is your family here? Congratulations. And so what? It would have taken another minute, but it would have had, I think, a completely different tone. So I wrote something like that, a little blog about having witnesses pro forma hearing, and then I said, gee, this is the kind of thing that should be used for training, and is in its sense itself a kind of an amicus justicia brief. So we now have the new society. You see this website, the intltj.com. That's a very important one. My email address with the B in it is an important one too if you want to be in touch. But that's really, the little presentation I wanted to make about a new kind of legal writing that I think can just give people a sense of the methodology and how it can be used and how it can be really of practical value to all of the different participants in the system. And if we leave if we get away from the criminal area and we talk about special education law and matters like that, we can have this go to school boards and principals and other players in the legal system, completely apart from the criminal law area. Criminal one is the one I'm most familiar with. So I hope as a chapter you may consider thinking about some of this as you have new law proposed or passed in Israel, and maybe give students an opportunity to write something very short that could become a blog on all this. And that's it really for this. I would like to just talk a bit about the society, because that website is valuable because number one, it has lots of resources on it. It has a resource to the blog that I keep talking about. Now you can find the blog without even going to the website, but the website has everything together there. You go, here's a blog. Click on this, you see the blog. You want to join the blog, you just click follow and you put in your email address. You start getting these blogs. They're not overwhelming. They're short. They come every now and then, but at least you'll be kept up to date on it. And I encourage you to think about writing for the blog. It's just 1,000 words or less of a very short idea that you may have or thought that you may have about something. It has the TJ listserv, which is easy to join. And then you start getting email from other people working in TJ across the globe. There's a TJ Facebook page. But for our purposes, the most important thing is that we have the ISTJ TJ Forum. The forum is a members-only part. The rest of the site is open to anyone, researchers. But if you want to go to the forum, you have to be a member. Member means you've paid your $25 if you're an adult, or you have a student rate that's free. It's free through 2019. And once you put in your credentials, you can go to the TJ Forum. We're building up that forum. But right now, what it has is a number of, first of all, it has a general discussion forum. So you should go, when you go on there, you should click to subscribe to the general discussion forum, meaning anyone who has something to say that's of interest, they just say it on that, send it out, and it will go to every member who goes to that forum and checks, or if you're subscribed, you'll get a notification, new message from the general discussion forum. There's also now the Israeli chapter. You subscribe to that, and anything that's sent about or from the Israeli chapter will go to all of you and to others who happen to join, like I have, or even others who haven't joined. If they go and they're members of the society, say, let's see what the Israeli chapter is up to, they can go and click on it. But this is a place that should become kind of a local listserv for you, where you should feel free to write in Hebrew. You can write in English if you want to write something that you think would be of great interest outside of Israel. You can also go into see what the other chapters are doing and writing. There are a number of them now, and we're just getting them off the ground. But you need to get in the habit of actually using it. For example, there's one thing in there that talks about this meeting. But who put it there? I did, because
you're the best at it.
I did, because it's something that it really takes a habit to say, oh, this is important, and the Israeli chapter should know about this. So anytime the Israeli chapter should know about something, you guys should put it in there, and then everyone who's a member here will actually get it. Much better in that sense than the TJ listserv, because you don't really want to advertise to everyone in the world, especially if you're doing it in Hebrew, that there's something happening. But this would be really mostly for your own use. You should also there are also besides chapters, which are geographical, there are interest groups. And there are very few of them so far, but there are two that are terrific. One is a judicial, and they're just getting off the ground too. And they aren't that great at posting yet either, but they're about to get there. There's a judicial outreach group filled with some really good judges from around the world, plus others who are interested in courts and court administration and all that. They want to come up with training materials. These could be very, very international in use. They want to make sure they circulate different things. They have done so a little bit already, but they're really going to do that. Pauline Spencer, a magistrate from Melbourne, Australia, is a co-chair. Some of you know her. She's terrific. And Jamie Houston, a retired Baltimore drug court judge who now splits her time between Baltimore and Germany, is the other leader there, but has a lot of good members, and it's, I think, a very, very great potential chapter. There's also a social science and a social science TJ chapter, because there had been grumbling over the years that it's sort of too heavily law-oriented. We have a lot of good social scientists. Astrid Bergden kept complaining, we need more social science, more social science. We said, okay, Astrid, you got your wish. You are now chair of the social science chapter, together with Anne-Marie Dewhurst from Western Canada, who's a counselor, I think. But that's a perfect place to put in something about new social science developments or findings or insights that might find their way into the law or legal practice or courtrooms. So I think it's really, really good. The other thing is you have an Israeli TJ center here, as well as your institute. There's also one in New Zealand, there's one in Australia, there's one in Japan, and I think it would be a great opportunity to get all of those centers together through chapters and whatever, and to share different developments with them. But the most important thing, as I said earlier, is that TJ is sort of an evolving, developing, dynamic discipline, and it really needs the energy of others to think about something, to critique it, or to say, well, this would be a great thing for an amicus justitia brief, or some other kind of thing will pop up and come out. And we have a lot of really talented people with a lot of diverse backgrounds who can think of a lot of stuff that just a couple people are not going to think of. And so for TJ to develop, we really need all of this talent, and we sure have a lot of it here. So go to it.
Thank you, David. Thanks.